to say you these first words. Welcome at this conference on online intermediation and competition in e-commerce. Welcome to the participants and to the distinguished speakers. And first, I may say to Dr. Giovanni Pitruzzella, Professor Giovanni Pitruzzella, President of the Italian Commission Authority. And I am very pleased for this conference, and I am very grateful to my young colleague Margherita Colangelo for having organized this meeting. And I'm very pleased because the intermediation competence on e-commerce is really a very new topics with the new problems which are under focus in this period. And this demonstrates once more how much the Department of Law is able to make focus on the new aspects of functioning of our society. This related to internet and to legal intermediation as to digital markets. And so I am sure that the results of this conference will be very rich. And I give immediately the word to Giovanni Pitruzzella, who is, as I told you, but you know, the President of the Italian Competition Authority, for the introduction of this meeting. Thank you.
Good morning, ladies and gentlemen. First of all, let me thank the organizers for inviting me to introduce this extremely interesting conference dedicated to a crucial topic, the digital economy and the increasingly important role that e-commerce and online platform play in our lives and our economies and their implications with competition policy. It is obvious that the peculiarities of the dynamic online competition may imply physiological situations of winner takes all, and that often represent a reward for the superiority in innovating and managing technology, rather than anomalies in the structure of markets. It is rather obvious that many very successful internet-based companies are near monopolists. Google, YouTube, Facebook, and Skype are typical examples of internet firms who currently dominate their relevant markets and who leave only limited space for a relatively small competitive fringe. In other words, the potential of new online services for our societies and economies is huge, but bad news is that digital markets may present some barriers to entry. It is certain that competition policy faces new types of challenges in cases related to the digital economy, compared to those in more traditional sectors. Indeed, digital economy is unique in a number of ways. In particular, competition between platforms is characterized by network effects, switching costs, reputation effects, and economies of scale. While the strength of these effects differs heavily between markets and platforms, the effects are typically more important than in standard physical markets. As the firm's conduct is increasingly encountered with suspicion by competition authorities and consumer protection organizations alike, the obvious question emerging is whether current competition law instruments are sufficient to address the emerging competition concerns in digital platform markets. In my opinion, one of the crucial questions from a competition policy perspective is not so much whether these firms have such a dominant position today, but rather why they have such a large market share and whether this is a temporary phenomenon or not. Do these internet monopolies enjoy dominant position because they are protected from competition through barriers to entry? Or do they just enjoy the profits of superior technology and innovation? Are we observing some Schumpeterian competition where one temporary monopoly is followed by another, with innovation as the driving competitive force? Or are we dealing with monopoly firms that mainly try to close their market to new firms through anti-competitive behavior? These are some of the key questions for a competition enforcer. Trying to answer these questions, competition authorities can gain important insights on how digital markets work from individual cases. For example, Booking.com, Google, TripAdvisor are only a few of the digital companies on which the Italian Competition Authority has intervening, enforcing its competition and consumer protection competencies. Let's consider the recent Booking.com case. In their investigations of so-called price parity clauses, also called the most favored nation clauses, contained in agreements between online travel agencies and hotels, the Italian, the French, and the Swedish competition authorities coordinated their investigations and, in April 2015, adopted parallel decisions accepting identical commitments from the market-leading online travel agency Booking.com and making them binding in their respective jurisdictions. The European Commission assisted the authorities in coordinating their work. In the course of the investigations, Booking.com argued that parity between room prices in hotels, home sales channels, and prices offered on Booking.com's platform is important in preventing free riding on Booking.com's investments and assuring the continued supply of search and comparison services free of charge to consumers. To solve the competition concerns, Booking.com offered commitments that prevent Booking.com from requiring hotels to offer better or equal room prices via Booking.com than they do via competing OTAs. In addition, Booking.com cannot prevent hotels from offering discounted room prices provided that these are not marketed or made available to the general public online. The discounted prices can be offered online to members of a hotel's loyalty scheme and via offline channels. In conclusion, Booking.com's commitment found an appropriate balance between preventing potential restriction while preserving operators' ability to develop and provide innovation services. I think that Booking.com was a successful case for many reasons. The importance of economic analysis, cooperation and coordination with other EU competition authorities, and timing, which is crucial when competition authorities deal with innovative and rapidly changing markets. The development of new apps and the adoption of technological tools like, for example, the taxi app Uber and the implication of the so-called sharing economy are causing worldwide complex issues of interference with traditional services. In front of disruptive innovation, there is the tendency of some to succumb to protectionist impulses. In this context, the Italian Competition Authority has just adopted an advocacy opinion hoping the legislator to intervene in order to regulate in the least invasive way possible these new forms of transportation for the benefit of consumers. Rules should be provided to regulate activities of urban transport carried out by non-professional drivers through digital platforms, in addition to or as an alternative to taxis and private chauffeurs. It is important, in our opinion, to regulate the sector to ensure competition, road safety, and the safety of passengers, defining a third kind of drivers as well as those of taxis and chauffeurs. E-commerce, the last issue, has also brought about the empowerment of consumers. But at the same time, e-commerce is fraught with issues of its own, some of them of a sui generis nature. In this regard, many are the challenges in order to protect consumers. In the sector of e-commerce, coherently with the initiatives undertaken in the competition enforcement, the Italian Competition Authority intensified its activities on the conduct of the operators, with particular attention to the correctness and completeness of the information given to consumers, the quality and safety of products offered for sale through the web, the respect of contractual prerogatives of the consumers. In other words, we believe that neither static nor dynamic competition can properly work if consumers are not placed in a position to fully exercise their role in the market. For this reason, I think that this conference will be very useful for the Italian Competition Authority. I'm looking forward to listen to the speech and to read the books that will be published afterwards. Thank you very much.
Professor Pitruzzella for introducing the basic problem to be considered later in this conference, basic problems, but also having regard to specific fields of e-commerce. And so I believe you had to you have to leave because and now I give the floor to the chair of this first session, who is Alberto.